Hey everyone, I'm Diana Davison, an advocate for the falsely accused and wrongfully convicted. I want to talk today about a case that highlights an absurdity in Canadian sexual assault law. This is a case where a young woman claims that, despite being pregnant, she was a virgin. The girl was sent to a clinic and the fetus was aborted, then disposed of, before DNA testing was done to determine paternity, so the only evidence against the accused was her testimony. As you can imagine, virginity became an important subject at trial. Virgin births aside, the main issue of concern is that while defense can't argue that a sexually experienced woman is more likely to consent, the prosecutor can argue that a virgin is less likely to consent, and more worthy of belief. There is a fair bit of case law on this, allowing for prosecutors to argue that. In this case, consent was not an issue because the girl was a minor, 15 years old, and the accused was 20. The question became what the girl thought being a virgin meant and whether or not she'd been in virginal contact with anyone else who could have impregnated her. The verdict does a wonderful job identifying the logic problems at play, but to start out with, you need to understand the basics of what's called rape shield law. There are two main arguments that are barred in court. They're referred to as the twin myths. That a woman who's promiscuous is 1, more likely to have consented to sex, or 2, less worthy of belief. So just because a woman isn't a virgin doesn't mean that she'll sleep with anyone. Just because she's had sex with someone in the past doesn't mean she'll always want to have sex with him again. Just because she had sex with, say, 2 guys at a party doesn't mean she also agreed to a 3rd one, etc. Also, you can't say, "Don't believe her, she's a slut." This is referred to as prior sexual history. And any time evidence that involves a sexual experience is sought to be introduced at trial, there's a special hearing called a 276 application that's required. 276 is the section of the criminal code. The judge will be told what the evidence is that you want to use or what line of questioning your lawyer wants to embark on in cross-examination, and then a debate ensues as to whether or not the evidence would violate the twin myths or otherwise prejudice the court against the complainant without good cause. In legalese, this is called probative value outweighing the potential prejudicial effect. So back to the virgin birth case. The prosecutor argued that the girl's pregnancy was proof that this particular man was the one who had sexually assaulted the girl. Obviously, he wanted to cross-examine the girl about possible other sexual contact she might have had with other people that summer, but the judge refused to allow it. Overturning the man's subsequent conviction, the appeal court said this. In paragraph 3, here the Crown claimed that the complainant's pregnancy corroborated her sexual assault allegation, the implication being that only the accused, R.V., could be the father. Yet the application judge refused to allow R.V. to attempt to challenge that proposition when cross-examining the complainant, a witness who would clearly be able to answer those questions. That decision was in error. Further down, they deal directly with the virginity issue. Paragraph 78. To be sure, it's well settled that a complainant can testify to her virginity without triggering Section 276. As explained in R. v. Pitteman, 2005, evidence of a complainant's virginity is a question of physical fact, not a sexual experience. It does not follow, however, that defense challenges to claims of virginity fall outside of Section 276. Such a challenge, by its nature, entails the proposition that the complainant has had sexual experiences. Even a binary question about virginity, such as, "Are you telling the truth when you say that you were a virgin?" invites the answer no, which is evidence of sexual experience. Cross-examination that challenges claims about the absence of sexual experience falls squarely within 276. You would think at this point that this is a scene from a Monty Python movie.
Well, if it's not a personal question, are you a virgin?
If it's not a personal question, how much more personal can you get? Now piss off!
She is. Yeah, must be.
Who says the law courts are boring? Now, there's insufficient information in the appeal verdict to come to a conclusion about what actually happened in this case. For one, we don't know how many other people were at the campground that fateful summer, other than the girl and the cousin she accused. But there is some intriguing information about how the girl's pregnancy was discovered that gives some indication she might not be completely honest. First of all, she went to her doctor about nausea and abdominal cramps, and on August 29, 2013, the doctor arranged an ultrasound and pregnancy test. On September 2nd, 4 days later, the girl had sex with her 17-year-old boyfriend for the first time. The tests were done on September 14th, confirming that the girl was pregnant, and then she said she thought it was from sex with her boyfriend just 12 days earlier. They go back to the ultrasound and determine that she's been pregnant for almost 14 weeks. Now, I'm going to make a guess here. I think she knew that she was pregnant. She didn't want her boyfriend to find out that she wasn't a virgin, so she rushed off to have sex with him before the test. When she couldn't fool the doctor, she had to make up a story that also supported her being a virgin. Given that the girl was having these unpleasant physical symptoms, rushing off to have sex with her boyfriend 4 days after the doctor's visit seems to be agenda-driven sex. Basically, it seems like an attempt at a cover-up. But the appeal was only focused on the one issue. If prosecutors can adduce evidence about virginity while the accused can't question it, are these fair trials? In this case, the prosecutor actually questions the complainant later about sex with her boyfriend. You know, a different sexual partner, a different sexual experience, not related to the subject matter of the complaint. And the prosecutor does this to bolster the theory that the girl was a pregnant virgin. I never thought that I'd see a case where the prosecutor offered proof of virginity as proof of rape. It's all just so absurd.